Good morning, Christopher Hurley for the plaintiff. I'm going to pick up on that last issue just because I think it's fresh in everyone's mind. Actually, there's no way they knew that this child had a genetic Angelman's at the time Timothy was in those early formative days. What happened was Mrs. Clark heard about a study that was being done by somebody who was trying to study children who had random Angelmans, who had no known genetic cause. And as a result, she applied for the study, and the doctor said, well, yeah, you can be in the study. Let's see all your genetic tests. And so she went and got her file, handed it to him, and the doctor said, well, where's the UBE3A test? And she said, well, it should be there, and it's not. And so then she went on a quest to try to get it from one of her two board-certified geneticists that had told her she had no genetic cause for Angelman's. And that doctor was not compliant. She finally had to go to Baylor, and it wasn't until September 30th, less than 2 years before we filed against this defendant, that she was told on the phone by some person who is unnamed, we don't even know who it is, yeah, this test is abnormal. So that was the first time she found out there was a genetic cause, and as Your Honor just pointed out, Angelman's can be genetically caused or it can be random. If it's random, then there's no cause of action here of any kind. And so it's not until she knows that she had the genetic form that she knows she has a cause of action. And it wasn't until she then contacted a lawyer after she found that out, and we chased it down, got the report, and found out it was, in fact, a genetic cause. So there's no way she could have known this was wrongfully caused until that day. Going back to the first issue that was discussed, the defense has tried to redirect the court on this topic to what the parents are liable for paying for their children, minors or adults. The issue here is, what should a tortfeasor be liable for paying as a result of causing an injury? And in this particular case, this is a common law tort that was recognized by this court in Siminiac 23 years ago. And what the court recognized is that the parents are the victims here. The parents are the ones who have been harmed by this negligence. And so then the question becomes, who's going to pay for the damages? Well, the damages in Siminiac didn't, or at least they weren't pled to have gone into the years after the child was going to be 18. Here, these damages are going to continue for the life expectancy of this child. And that will be, at least well into his 70s. These children are profoundly brain damaged and need 24-hour-a-day care. To take them to the dentist it's not a matter of going in for a 25-minute appointment. It's about a 3 or 4 day process. They have to be put under general anesthesia. So when this child is 25 years old or when he's 35 years old, those extraordinary damages are going to continue to accrue. Okay, those damages have been caused by a tortfeasor, and the tortfeasor should be held responsible for those. To suggest that, and there's practical problems that will be associated with this for this family going forward. Many healthcare providers, or many of the best healthcare providers, will not take public aid or Medicaid. And so, for example, Mrs. Clark takes Timothy to St. Louis for his eye care. There are no guarantees that the state or the federal government will have the money to pay these damages in the future. And I actually would compare this to more or less to a collateral source type argument being made by the defense, where they really want the benefit of the fact that, well, the family can go get this money to pay for these expenses from the state or from the federal government in some way, so we shouldn't have to do it. They're trying to get the benefit of the hope that some third party will pay these costs in the future. And I don't think that is or should be the public policy of the state. I think the public policy of this state, I think recognized in Siminiac, is that when someone is negligent, and that negligence results in extraordinary damages that are going to last forever.
On the other side of that public policy argument, we have law in Illinois that the parents are no longer responsible at the majority. So if they should prevail, there's nothing that would prevent them, not that I believe that they would, but from walking away from the situation and still leaving it at public's expense.
I think that's something that this court can address. I think this court has the power to address that if it chooses. And I think there's two ways that you can go. One is we can prove and will prove at trial that this family is going to take care of this child for his entire life, and there's no question that's going to happen. If the court's not comfortable with that, I think the court has the equitable power, as the court did in the Florida case, which is called Cush, to say the money will be held in trust for medical expenses. If there's some concern by the court that the parents won't use it as it should be used, that can be done, and I think should be done. This is a common law tort, which has some unique aspects, which I think you just pointed out. How does the court know that the parents will spend the money on the child? I think we can prove it. I think a jury can find that we can prove it. But I also think if the court, and I think this court has the power to make the common law, and the common law maybe ought to be that the money is held in trust for the child. There'd be no objection to that on our part. But in any event, I think that it's important to recognize that the attempt to sort of tie this type of case to various statutes which are and have been enacted for other reasons really is an attempt to misdirect the court from the real issue, which is that the tortfeasor should be liable for damages it causes. So what I'm saying is, the Family Expense Act, enacted over 100 years ago, to make sure that families don't fraudulently avoid their creditors, really was not written with this type of a case in mind. And this case really has to be ruled on a case-by-case basis, as I think the court hinted at in Semeniak by not going to the majority issue at that point. They're just waiting for it to come up.
So are you saying that you don't agree that the law currently is that parents have no responsibility for their child's medical expenses beyond majority?
Well, I don't.
Are you not telling us it's a case-by-case analysis, are you? Or maybe you are.
Well, I think that realistically, in this case, the parents cannot, I agree with the court, the parents cannot be sued for the child's medical expenses past the age of majority. But as a practical matter, when this boy is 20 years old, he's going to need some medical care. The parents are going to have to take him into a provider, and the provider is going to say, who's paying for this? If the state's not there to pay, or if the state chooses, for whatever reason, if the state doesn't pay, then the parents are going to have to pay because obviously the child doesn't have the ability to enter into a contract. So these damages are going to continue to accrue regardless of whether the parents can be sued or not for the damages. Now,
is this something that ought to be addressed by the legislature?
No, I don't think so. I think this court's the proper place to establish common law damages and common law torts. To expect the legislature to drill down to an issue as fine as this one and get it right, I don't think is too likely, and I don't think it's something this court has to wait for, because we may be waiting a long time for something like that. I think the proper way to handle common law tort damages is for the courts that make the common law to establish what the proper damages are. And so just to suggest that because the parents can't be sued for these medical expenses after the boy is 18 does not change the fact that these expenses are going to be accruing over the years. They're going to continue to happen. And it should not be a windfall that falls upon a tortfeasor to not have to pay these just because of that. I'd like to touch on the...
Does this differ from the hemophiliac?
It is. The hemophiliac case, or the Semeniac case where the child was a hemophiliac, at the age of 18, there was an indication, I think, at least in that decision, that that boy would be able to enter into his own contracts and get his own health insurance and pay his own debts. And so there was no suggestion that the parents were going to be saddled with this burden for their whole lives. I mean, the point in this case is that we have these parents who will have the burden of rearing this child for their, for his entire life and their entire lives, and so it does differ. The distinction between this case and other cases where parents maybe try to get damages for their emancipated children is that, if there's some auto wreck and your child's involved in an auto wreck, he can get all the damages for himself in his own cause of action, or his estate can get it. In this case, because of the nature of the wrongful birth, only the parents can get damages. The child isn't entitled to get any damages. So under the law, there's not going to be a double recovery here, allowing the parents to get these damages. So I think there's a major distinction between the cases cited where parents aren't able to get damages for adult children. There's a reason for that. The children themselves can get those damages. In this case, the children can't get them, and the damages end up not getting paid by anyone if you don't allow the parents to recover them. And as for the wrongful or the emotional distress issue, I'd like to touch on that briefly. Defense skipped over the Corrigan case, which is a 1991 Supreme Court case, where this court specifically held that where the party is a direct victim of a tort, there is no need to plead a zone of danger. And so in Corrigan, there was a psychological malpractice case where a psychiatrist was having sexual relations with a patient. And in that case, the court reasoned that, the patient is the direct victim and so does not need to plead a zone of danger. And here, in the wrongful birth context, the parents are the direct victims. The parents in this case specifically went out into some trouble to make sure they didn't have a genetic cause of this Angelman syndrome, because they knew that the burden of dealing with one child was great, but dealing with two children under this with this condition is exponentially more difficult. And so they went to a great deal of trouble to make sure they didn't have this condition. Then when they get this child, it is literally their worst nightmare. And the emotional distress is a real thing that they experienced. So the negligence went directly from the doctor to the parents, and the parents are suffering for it. So there's no reason under the Corrigan reasoning why they have to plead a zone of danger at all.
Did Corrigan not say that the plaintiffs in a wrongful birth case are bystanders?
I think that in Corrigan...
And not direct victims?
I don't remember that exact quote, Your Honor, but I do have I do think that what I was relying on was that they note that in Semeniac, the majority's mere failure to address the direct victim/bystander distinction does not amount to an expansion of the zone of danger rule to include direct victims. So my feeling is that in Corrigan they didn't really overrule Semeniac. They just sort of recognized that the Semeniac decision didn't go into this topic in depth. And I think in reading Semeniac that's accurate. The only point I'm making is that I don't think the parents are bystanders here. The parents physically, walked into a doctor's office and asked for this specific advice. Please tell us if this is going to happen again, because if it is, we're not going to have another baby. They're given the wrong advice, and then the worst thing that they can imagine happens. And now they suffer for it, not just, as soon as they discovered it, but, for the rest of their lives. And so I think it's a classic common law tort where there's negligence, there's proximate cause, and there's injury, and now there needs to be damages. And Corrigan goes on to say, more than one, I think at length, that it should be the jury's decision as to what these emotional distress damages are.
So that whole issue will come over here. That whole issue, Mr. Hurley, will revolve around the fact of whether this court finds them to be victims or bystanders. You would agree that if we find them to be bystanders, the zone of danger does apply?
And if that's, I think that's right, Judge. If they are considered to be bystanders, then we need to plead that they were within the zone of danger, which we did, and which I believe they were. I mean, so if you come to that conclusion,
Was there any, in the pleadings, did the plaintiffs ever plead that their physical injury resulted from the emotional distress?
Well, I think that there's...
or any physical injury resulted from the emotional distress?
What we plead is that the children are actually physically dangerous at times, and so that causes physical injury to the parents.
But isn't that after the fact of the birth? I mean...
I think it's an ongoing injury, Your Honor. I agree with you. It is after the fact. But the tort doesn't end the day the baby's born. The tort is going to continue for his whole life. And the damages are going to continue.
But I'm talking about the zone of danger for the plaintiffs.
Well, I think that, I think as Justice Simon pointed out in his dissent in Simanak, and I think as Corrigan starts to recognize that zone of danger is a legal fiction that is created to avoid situations where people fraudulently try to piggyback onto accidents. The best way I can think of it is my office overlooks a busy intersection, and there's hundreds of people that could be looking out the window and see an accident, and we can all run down and file lawsuits saying we were upset by it. So the zone of danger rule is designed to sort of limit that kind of a problem. In the context of a wrongful birth case, that's just not even a realistic issue. I mean, there's not a chance that fraud or anything like that could come into play here because there's this one baby and there's two parents and they got these medical this medical advice. I think the courts in the Colorado decision, Linenger, and the Florida decision, Cush, are instructive on this in that they just recognize that wrongful birth cases don't fit into the cookie cutter mold of the need for zone of danger evidence. I mean, having said that, we still pled it in our complaint, and we still take the position that we're within the zone of danger. But I'm being perfectly frank with the court. I think that these types of cases just aren't good cookie cutter cases for that type of for the zone of danger rule. So the only other point I'd make is if the court's interested in the statute of limitations issue, it was never appealed below. It was not on a final judgment, and ultimately it's a question of fact for the jury, and that is because there's just no question that this family did not know there's a wrongful cause to this until that day when they were advised that this was a genetic cause as opposed to the random type cause. Thank you.
Thank you, counsel.